coming out to what is, it feels like in this room, of course, would be a UT Law School faculty colloquium, but in fact this is a Strauss Center for International Security and Law event. If you're not familiar with the Strauss Center, I should probably say something about it. I'm the director. I'm Bobby Chesney. I'm a member of the faculty here at the law school. But one of the other hats I wear is to direct this enterprise we call the Strauss Center. And what it is a university-wide center that is designed to bridge across the different departments and schools and colleges on our campus. In particular, to do so, to bring together people from different disciplines to work on current public policy relevant problems where an interdisciplinary perspective might be useful. And our speaker today is the very embodiment of that sort of approach and that sort of thinking. It's Professor Ryan Calo from University of Washington School of Law. Ryan's been there for several years now. He's not just a law professor there. He too also has a second hat as a type of center director, although in his case it's a lab. It's the University of Washington Tech Policy Lab, which does all kinds of cool work at the intersection of law, technology, public policy, and other things besides. Prior to coming to University of Washington, he was at Stanford for about 4 years as the director of their privacy and robotics program. We're excited to have him here this week, not just to give this talk, but he's actually teaching a short course, a one-credit evening course here at the law school on this subject, robots in American law, legal and policy aspects. Please give him your full attention and prepare to hit him with some good, hard questions when he's done. Ryan, welcome.
Thank you. Okay. Thank you very much, Bobby, and to the Strauss Center and everyone here for welcoming me into your community. As Bobby said, I look at the legal and policy aspects of robotics, which, when I first started doing this a bunch of years ago, I got a lot of questions about Isaac Asimov and whether the robots were going to wake up and kill us, and hopefully there'll be some questions like that today. I'm always happy to field them. But over the years, it's been immensely gratifying that in many ways, at least the United States and other jurisdictions as well, sort of caught up to the importance and relevance of robotics, and as a consequence of that, I've been able to do some really interesting real-world things. For example, I testified before the U.S. Senate about the domestic use of drones. I helped the state of Nevada fix their driverless car, their pioneering driverless car bill when they were the first state to pass such a bill. And I'm now working with the Department of Homeland Security, with the White House, with NSF and others to try to fashion the sort of wisest domestic policy around robotics and automation. So it's been a very interesting ride. I'd also just say that I tend to be focused very much on the immediate commercial prospects of robotics and not the more speculative stuff, although I'm very, very happy, of course, to talk about it. I find it intellectually fascinating. So, one of the things you think about robotics law is that it tends to be divided into two sorts of kinds. So there actually is a considerable amount of literature, both within the law and without, talking about the intersection between law and robotics, or policy and robotics. It tends to have two essential flavors to it. One is that it's a very narrow look. So this would be something where you actually look at a particular technology like drones and look at their privacy aspects. And that's interesting and helpful, right? You learn a lot, but you don't learn much about the general community, the general theory behind robots in the law as a body, if there is such a thing. You don't have lessons that you can export beyond the particular context in which you're working. So it might be product liability in cars, driverless cars, or it might be privacy in drones. It's very, very specific, but good, careful work, and there's a lot of that. There's also work that is much more about robots in general and the kinds of challenges that robotics may present for law and policy. And there's been a bunch of that work, dating back at least to the 80s. And it's fine theoretical work. The issue with it, of course, is that it tends to be wildly, maybe wild's a little too colorful a word, but it tends to be very speculative. The idea is that, robots are going to be really interesting in the future, they're going to pose these legal challenges, we should take a look at that. And so my effort over the last few years has been trying to talk about robot law in general, but to ground it in something more concrete. And so this effort here on Robotics and Lessons with Cyber Law, is my last paper on the topic, is about what special, interesting puzzles that the internet created for the law. and then using that as a jumping off point to talk about the kinds of different issues that robotics will pose. So the idea was to look at the internet and the fact that you can talk to people at a distance and you create these communities that are nowhere in particular, and what challenges it brought on for jurisdiction and copyright and so on. And so then I decided to do that exercise prospectively and to look at what is it about robots. They engage in this emergent behavior you can't predict. Not only is there action at a distance, but it's a physical action and so forth. And so I did this exercise and went through what I thought would be the puzzles that robotics would generate. So I got a couple of responses to this paper, one of which I want to highlight here, which is by Jack Balkin. I think, Cindy, you and I had lunch with Jack one time, I recall. And Jack wrote this response. He's a law professor at Yale, and he said, look, it's all well and good, Ryan, to talk about what puzzles the internet made for the law in 2015, because now we have 2 decades of experience with this technology. But you couldn't have done that in the early 90s when all of us started to look at cyber law, right? I mean, at that point, we had no real good sense of where this was all going. And in fact, the internet winded up being very, very different than the way that it looked at the time. And so Jack says, so you can't really look forward and ground it in that, because at the end of the day, we don't know where robots are going. We don't know where robotics is going. And so you can say some interesting stuff, and I agree that this is a paper is important, but at the end of the day, we will see. We will see what happens. And so, Jack's a very smart guy, and I very much sort of initially thought to myself, okay, back to the drawing board. But then I started to think a little bit more about this, and I thought, is it true? Is it true that we are really in the position today with robots that we were with the internet in the early 90s? And I decided that that probably wasn't true. So this is a picture of me when I was my son's age in kindergarten. I was about 5 years old, and you can see that I already have an advanced robot next to me.
That's not a robot, it's a totem.
It's a totem, yes. Well, it's a remote control totem, though, because this little base actually moves around. So we can talk about what a robot is. But the point is that, at least since the 1950s, even the late 40s, we have had robots in American society. I mean, we've had them in factories. Over the last couple decades, our military, which of course is the strongest in the world, has absolutely revolutionized warfare through robotics, as Peter Singer chronicles in Wired for War. And increasingly we have them today, but they have been in American society for a long time. And so I thought to myself, well, like most technologies, perhaps they have actually caused legal disputes. And so I went back and looked. I and a team of researchers went and looked at every instance in state and federal court where the word robot was mentioned. Now, of course, in many of those instances, the word was mentioned in passing. And so we had to come up with a heuristic in order to try to figure out whether the court was just sort of saying it in passing or whether or not it seemed to be important in some way to the case. So the heuristic that we use, which is admittedly imperfect, is the idea that it would appear in the headnotes or in the syllabus. In other words, the description of the facts, written later by lawyers, not by the judges themselves, of course, or by the court, but the facts or the headnotes, that is to say that it factored into the decision of the judge. And so even when we did that, we wound up finding a bunch of cases in which the role of the robot in the case was incidental. What do I mean by that? Well, I just mean that it could have come out the same way with a toaster or something else, right? And some of these were really fun and colorful. One of my favorites is, I don't know if anyone's ever seen this movie, Maximum Overdrive by Stephen King. It's actually about machines that come alive and harm people. And on the set of Maximum Overdrive, there was a robotic lawnmower that suddenly went wild and injured a cameraman. And so while it is perhaps the most ironic case to come before the court, at the end of the day, it could have been a camera falling over and it would have been similar issues, right? So what I mean to say is that it's incidental, right? I mean, the fact that a robot was involved, it's not that the robot was driving the case in some way. And yet, I found dozens of cases where I offer to you that it mattered that it was a robot. That it actually mattered to the case in some key way that we're talking about a robot. And these are supposed to be the examples that then respond to Jack. Some of these cases are pretty well known, and they might appear in a textbook. This is the case of White v. Samsung from the early 90s, from 92. It's a case in which Samsung made a print ad and it was saying, we'll be around, and you'll use the VCR, not that we even use VCRs in 2012, but anyway, they're saying we're going to be a technology company in the future, even if we have to tape the longest running game show. And of course they put, instead of actual Vanna White, they put a robot Vanna White. Actual Vanna White got upset about this, and she said that this violated her rights to publicity. She wound up suing. Case went all the way up to the Ninth Circuit, and it was a very interesting case. The majority itself was deeply conflicted about the central question, which was in essence whether or not this robot could represent a person, or whether it was a distinct entity that could not be said for the right of publicity to represent the relevant party. And so within the majority opinion in the Ninth Circuit, the court actually split in the sense that it decided that for purposes of statutory law in California, a robot could not represent a person, but in the purposes of common law right to publicity, which is more flexible, it could. Meanwhile, the dissent could not believe this. I mean, for the dissent, it was self-evident that, of course, and this is not paraphrasing, this is literally what the dissent said. One is a beautiful woman, the other is a robot. Okay? And this is what the dissent says, right? And so it's this interesting issue where the court has started struggling with whether or not a robot, an anthropomorphic robot, can be said to represent a person in the relevant way. It's a beautiful robot, yes, it's gorgeous, it's true, but it's not this beautiful woman that he was expecting. In the Ninth Circuit, again, a few years later, and again, this is not an unknown case. Many of the cases I found I've literally not seen anywhere in the literature, especially technology law literature. But this is the case of Went v. Host International 5 years later. Again, went up to the Ninth Circuit. In this case, it was the barflies from Cheers, which was that old show, a bar in Boston. And a very enterprising entertainment company made animatronic robot versions of them and put them in basically in hotel, in airport bars. So people would come up to the actual actors and say, "Hey Norm, I had a bar with you, I had a beer with you in JFK," and this upset the people that played these characters, and they wound up suing. And so again, the court had to decide whether or not, in this case, it was slightly different because the Host International, the defendant, had actually sought and gained permission from Cheers in order to do this, but not from the individual characters or the people that played them. But anyway, again, the court allows this to go forward. In White v. Simpson, she wound up winning a couple $100,000. In this case, also was allowed to go forward. Judge Alex Kaczynski, many of you know, Judge Alex is a very colorful judge out of the Ninth Circuit. He was furious about this case. He was furious about it. He wanted it to go see en banc review, and he took the relatively rare move of actually, when they decided not to review en banc as a court, to dissent from that decision not to rehear. And it's one of my favorite dissents of all time because it begins with the words, "robots again," right? So these are two cases that are in the literature and turn in some way that I'll describe a little later around the robot itself. But many of the cases I found have not really come to light. And I'm going to start talking about those now. So one of them involves the case of Chuck E. Cheese restaurants. I don't know if people know Chuck E. Cheese restaurants, but these are these kids' restaurants, and in a couple of the rooms, they have these animatronic bands, these robot bands that that play occasionally. And in this particular case, an enterprising comptroller, local tax authority, came and said, "I'm sorry, you realize that during a performance, you have to pay a tax on the food and the drink that you serve, right?" And Chuck E. Cheese said, "Whoa, wait a second, this is not a performance. This is just a bunch of robots, that we like. It's a performance. They're on stage. They have instruments. I'm sorry, I don't understand." So a court had to decide whether or not robots could perform. And they went into detail. What is a robot? What does it mean to perform? And the court decided that in order to perform, you needed spontaneity, and that these creatures, these animatronic robots, lacked spontaneity, and therefore they couldn't perform. In a much earlier case in the 1950s, this is actually not the object at issue, and I'll get to this case too. But a court had to decide whether or not what tariff to attach to a robot that was being imported into the United States. Why? Well, it turns out that at the time, in the 1950s, there was less of a tax on imports on dolls. And the way the tariff schedule talked about, described dolls was as representing something animate. So people started to import these little wind-up robots from Japan, and they said they represent something animate, so that we should get taxed like dolls. And the customs authority did not think that was the case. So a court had to decide whether or not a robot represents something animate. And it went, again, figured out what a robot is and what it meant to be animate. This long discussion. And what was so fascinating about it was that the court ultimately couldn't decide in a way. So what it decided was that while a robot is a mechanical man and therefore represents something animate, the toy is not a robot. The toy represents the robot, which represents something animate. And so therefore it doesn't represent something animate, and therefore it is not going to be taxed as a doll. Okay? Later on, the court had to decide whether or not this toy represented something animate. Whether or not specifically the fact, and I don't know if you can see this very well, the fact that there is apparently a person in here. You see, this is an astronaut, and there's a person in there, whether that made it a doll, right? And the court struggled with this and couldn't figure out how to, and ultimately decided that just because you introduce an element that is like a person doesn't take something otherwise mechanical and convert it into a doll, which was very interesting in part because they had just got them saying that a robot was animate, and now they were saying that this is a mechanical thing. And so they just talked about how, after all, people don't usually walk around with guns coming out of their chest, right? And so they struggled again to try to figure this out. So these
Will
are
you
all...
take a question? Or?
Yes, of course.
Could it ever conceivably be the case that an issue in a case would be whether a robot is animate? I mean, that is so far out there that I refuse to believe that it's ever even arisen judicially in a court of law.
Well, I guess what I'm trying to tell you is that a closely related case of whether a toy robot is animate did arise.
Animate?
Animate.
Animate means alive.
I get it. But the question is whether, I see what you mean, whether it itself is animate. Not that it represents something animate, but
Well,
itself
are you
is
talking
animate.
about representations or the thing in itself?
To be very clear, I'm talking about representation. Because after all, we're talking about a doll. And under the tariff schedule, the doll is supposed to represent something animate. So if it's a doll of a human or a doll of a dog, that gets taxed differently. And here the question is whether a robot even represents something animate. You see what I mean?
But you're talking about representation.
I am. And so in fact, the cases that we've talked about so far are all cases involving representation in some form, whether we're copying a person or representing them some way. I want to pivot a little bit, and I hope we talk about this more, you and I and everyone else, about a question of whether or not a robot, not that it represents a person, but whether it can extend a person in a meaningful way. So courts have had to grapple with whether or not the use of a robot in a particular environment places that person in the environment in a way the law cares about. So for example, in the case of Columbus American Discovery Group, this is from 1992, what had happened was that there was a shipwreck that was very difficult to find, and ultimately they were able to find it and to observe it only through the use, developed in the 90s, of robotic submarines, right? And so at that point, having only reached the wreckage, this was an important wreckage, it was carrying gold from the California gold rush back to South America. They only reached it through the submarine. And then this company, this enterprising company that did that, wanted to exclude at maritime law everybody else and have an exclusive right of salvage. And so the court had to decide in this case whether or not you could possess exclusively a shipwreck only by reaching it with a robot. And not only did the court find that, but it found a 4-part test for telepossession that became very important and was ultimately used then in the famous case involving the Titanic. And it had this, you had to be able to manipulate it, you had to have live imaging, and you had to have the intent to possess on the part of the, on the part of the controller and so forth, and it became this test. Another case, this is way back, and this is not necessarily so relevant. This is a case from 1887 called Regina v. Hand and others. One of my friends pointed this out to me. This is a case in which allegedly some people defrauded an automatic box with cigarettes in it in the late 1800s by putting in a fake penny. they were charged with fraud, and the fraud was against the box, and I thought that was sort of interesting. But a much more relevant and interesting case was 100 years later in the case of People v. Davis. I don't have a slide about it, but People v. Davis was a California Supreme Court case in which the whole reasoning on the disagreement between the majority and the dissent was around whether or not you could burglarize a bank from off-site using a robot, right? Whether you entered the facility, which is what's required for those of you without legal training, for burglary, you have to physically be there. That's what makes it so bad. And they went back and forth about what the relevant test should be, and the whole ping pong ball was ultimately whether or not a robot could physically do it. All right, so this is just a sample. I don't have time to talk to you about each and every case that I found, but I did want to step back a little bit and talk about what lessons. So great, Ryan, you found a lot of robot cases, but what lessons do we draw potentially from this? So, one lesson that I drew was that this line between people and instrument is a hard one for the courts. They struggle with it, and I think they might be getting it wrong. And a related lesson might be that judges overall seem to have the wrong mental model of what a robot is. They think of it as being by definition without discretion. And there's more examples of this, but the performance one is one. This right here is a beautiful art installation in Brooklyn. It's called the Robotic Church. It's by an artist named Chico McMurtry. And when you go to it, these are all robots that he has built. It's a robotic church after all. And at any given time that the exhibit is running, it's always a little different. It's different because of the conditions of the day. It's different because what robots are working. It's different based on where you're standing. It's just different. And then you'd be hard pressed to go to this exhibit and not feel like there was a performance going on, right? And these are pretty simple robots. But contemporary robots, and even robots going back years, are capable of surprising us and displaying a level of spontaneity that I don't think the courts ultimately were countenancing. They had before them, in the case of the comptroller of the family entertainment, these almost jukebox-like, sort of robots that just did exactly the same thing inside. But the notion that a robot couldn't perform, or even that a robot lacks discretion, is probably not ultimately right. Again, judges seem to have increasingly outdated mental models of robots. Another example is, we talk, the idea of telepresence, the idea of a telepossession doctrine turns on these four-part tests. Contemporary exploration of the sea with robots takes place not necessarily by teleoperating, guiding these things yourself and looking at where they're going, but it happens autonomously. These are 3 examples of autonomous subs. You dump these things in the water and they go and explore undersea.
Excuse me.
Yes.
They can't be autonomous because there's somebody on the ship on the surface sending direction.
I mean that there's not. So while it's possible to take over the sub at any given time and operate it manually, I'm saying that these submarines, and by the way, these are used by the United States. We park autonomous submarines on the continental shelf in Asia. We have autonomous submarines in the military running, and people that are doing contemporary exploration of the sea are using these. And so these things
without any commands.
Without any commands whatsoever. So basic commands, and they are also important to understand that they have an autonomous mode. So like the Mars rover is another example of this, right? So we send the Mars rover to Mars, of course. Where else could the Mars rover go? And NASA basically tells Mars rover what to do, but then when it's not, it just puts it in autonomous mode, and Mars rover goes and explores on its own, and if it finds something interesting, it pings NASA. And this is how it works, and these are how the submarines work. And so this would not line up with our doctrine of telepossession, in part because who's forming the requisite intent to exclusively possess the shipwreck that this autonomous sub comes across? Right? And I'm not saying that we need a particular different rule. I'm just saying that these issues are very, very interesting. So first, courts are having trouble, just as we all do, deciding the line between people and instrument. There's psychology studies that suggest that people are really bad at telling you whether or not they think a robot is animate or not, actually. And for certain purposes, like, for instance, moral valence, people think that it wouldn't be right to torture a robot. Courts are struggling too. Second, that maybe courts have the wrong mental model. And the third thing is, then I'll stop here, is that an interesting development today is that we are actually diversifying the sources of robot law. And it's not just the courts anymore. It's not just decades and decades of courts looking at this stuff. but it's the National Highway Transportation Safety Administration sending a letter to Google saying, you know what, for some purposes, your software could be considered a driver under United States laws. And it's the Federal Aviation Administration promulgating rules about drones. And so, you know, these institutions have different capacities, different abilities. And so I think the diversification now, beyond just the courts, of the sources of robot law will be a happy thing. I'd even actually argued for the Brookings Institution that we could have a federal robotics commission, which I volunteered to be the chairperson. And they made this lovely seal for me in part. I'll stop there. And I've gone a little over time, but I'd love to hear your questions and thoughts. Yeah.
I'd support you, just you're too human for that job.
Is that right? Yeah, okay, fair enough.
So one of the things that you got me thinking about, a bunch of different things. A lot of the issues that seem like they would arise with robotics have to do with personhood and to which entities we're willing to extend rights. And of course, with corporations, we extend all sorts of important rights, famously, to legal fiction persons. Animal rights is an entire category that seems perhaps analogous here. And do either of those examples, either the corporate form or collective human organizations, or the evolution of animal rights concepts, do either of them provide useful analogies for the future path of robot law?
I think so. I think animals in particular are interesting and helpful. I would point to the work of Christopher Stone on standing. He talks about robots and whether they could actually ever have standing as a way.
Do trees have standing?
Do trees have standing? Of course, is the famous title of it. Yeah, but he also talks about robots in that work and animals too. And I think it's useful. So animals are useful both in terms of what they say about solving issues around emergent behavior that you don't necessarily expect a robot to do. We could think of it as being similar to in tort, which is what I teach, the one bite rule that says if your robot does something dangerous the first time, perhaps we use negligence, but if it does it the second time, perhaps we go to strict liability as we do with animals. But then take the example of copyright. So right now, being appealed to the Ninth Circuit is the question of whether or not a monkey can take a selfie. And I don't know if people know about this, but this is a case involving a photographer who leaves his camera next to him, and a monkey steals it and goes and starts taking pictures of the zoo and takes pictures of himself. And people think this is fascinating, and the photographer puts this on his website, and all the news organizations use this picture of this monkey that it took itself. And he, the photographer, files takedown notices saying, hey, this is my intellectual property. And a lot of the blogs go, no, it's not. It's the monkey's intellectual property. If the monkey were to send me a takedown notice, I would be happy to do that, right? But the point of the matter is that we might be an interesting way to get things in the public domain by arguing that patents or copyrights do not attach to any particular person. And these are live issues. I mean, in my piece, Robotics and Lessons of Cyber Law, I talk about the creativity engine, which supposedly invented a type of toothbrush for Colgate. And they had to contract around exactly who the inventor was, the people that created this creativity engine that they then lent to Colgate. So I think there are good analogies to to animals in particular. Although I do think we're kind of a far cry from the deep questions of personhood.
Just to follow up real quick, will AI's progress turn this into a conversation much more about AI and personhood rights than it is about robotics as such?
Yeah, I think artificial intelligence, and we can sort of draw a distinction between the two, as robots being more of the embodied form of this. But right. So I like the approach that Larry Solom at Georgetown has taken on this question of whether we can confer rights to artificial intelligence. He takes a very functional approach, and he says, look, we might be able to confer certain kinds of affordances and rights to certain kinds of artificial intelligences if they meet the requisite legal standard. So he's got a great paper about whether an artificial intelligence could be an executor of an estate, and whether or not those particular trustee, and whether those particular elements are met. It's very functional, right? But the idea that we would have full-blown sort of human-like rights for an artificial intelligence, I don't know that we'll ever get to that point, just because I don't know that the computer science will ever get us there. But if it did, that kind of would break the whole system. I mean, we have assumptions in the law about what a person is like. That they procreate a particular way, that they gestate for 9 months, that they mature for 18, and then we allow them to vote. You know what I mean? But with artificial intelligence, this would be immediate. And our assumptions would break down. Yeah.
So this is terrifically fascinating. A couple of quick questions. And taking the end of your presentation as the launching point, maybe you could say a little bit more about what you see as the prospects for developing a unified approach to robotics law rather than a disjointed and fragmented approach, and maybe what you see as some of the advantages and perhaps disadvantages.
Yes, I think
unified versus fragmented.
Sure. I think that for me it comes down to what the proper institutional configuration might be, right? And so, obviously there are debates in the law between who is better suited to keep up with developments in technology. So your Oren Kurz would say it's the legislature, whereas your Josh Rice would say it's actually the courts in the end. So I think a diversification is the right idea, right? So then perhaps good ideas will come from emanate from both places. The reason I proposed the Federal Robotics Commission sort of as a thought experiment was because it turns out that robot law is being made in a siloed way by different departments with different expertise, and they don't talk to each other. So it turns out that the same problem that the Federal Aviation Administration has to solve around how do we know that drone delivery of goods is going to be safe enough, how do we know that those things will avoid each other in the sky and not fall down and kill us? From a computer science perspective, it's awfully similar to the question of how safe does a driverless car need to be, in order for us to feel comfortable with on the road. It isn't even that different in a way from the question of how do we model whether high-speed trading algorithms are going to disrupt the stock market. And yet, of course, the Securities and Exchange Commission and the FAA and the Department of Transportation are not talking to each other. And none of these organizations have the relevant expertise. I mean, just as a motivational example, remember the Toyota sudden acceleration? Remember that? So these Toyotas were suddenly accelerating, people thought, and Congress said, I want to know whether this is a software problem. So they went to the Department of Transportation and said, is this a software issue with the Toyota? Because if it is, there's millions of cars that have this bug that cause them to accelerate for no reason. And the Department of Transportation goes, I don't know. How would we know that? And they're like, you got to figure this out, right? And so they're like, they don't know. So they actually wind up having to go to NASA, right? And can you imagine that, by the way, for a moment? It's like, they go to NASA and they go, would you take a break from putting robots on Mars for a moment and take a look at this Toyota for us? Right? And NASA says, sure. And they look at it and they're expert in cyber-physical systems and they come to the realization it probably isn't a software bug. Right? And that's fine in that instance, but that's not a sustainable strategy going forward. Right? So part of it is about attracting expertise, right, of the relevant kind and making government service of that kind sort of sexy the way it is with NASA and the NSA and so forth. Although conflicting today. But so for me, it's about institutional configuration. Who's best institutionally situated? Where's the record? It's a puzzle. It's a puzzle. Yeah.
Well, following on Professor Jink's idea about a unified approach, there's the institutional approach, which you just talked about. But wait a minute, you have to know from a unified perspective what it is that's being regulated, shall we say? And as you mentioned at the beginning, what is a robot? I want to take a very narrow approach to that question based on the paper that we received from Professor Chesney. Your Roman numeral number 2 is robots as legal subjects, and that's actually flipped. It should be legal subjects as robots, because you're talking about what happens when people act like robots. And the other equation or subject predicate is, robots as legal subjects. That's the kicker.
So on the question of what a robot is, we all have this habit of sort of thinking people have read our previous work when in fact, in my case, it's not true. I spent a lot of time on the definitions in my previous work because I think they're really important. And I wind up gravitating towards what's sometimes known as the sense, think, act paradigm of robotics, which defines robots as having essentially these 3 qualities, which is that they're able to sense the environment, they're able to process and think about what they sense, and then they're able to act upon the environment. And what I argue, and this is a common definition in computer science, less common in the humanities. When the humanities goes to define robots, they call them artificial people. When electrical engineering goes to define robots, they call it programmable machines. But in computer science, this is a very, not the only definition, but it's a bit of a consensus definition. So what ends up being interesting to me is like, how do each of these things, sensing, thinking, and acting that robots supposedly do, how do they particularly implicate the law, right? So the sensing part maybe implicates privacy. The thinking part The prospect that a computer will do something that is surprising to people, that is very interesting across a number of domains. So it's interesting around the ability to form mens rea in criminal law. I mean, there was, for instance, a bot. I mean, this is artificial intelligence, it's not embodied. But there was a bot that like threatened people at an Amsterdam fashion show. And was like, a bot is it's an online software agent that someone programmed, but it can behave in ways that are not expected, and it can say things that are not expected. And in this instance, neither the programmer of the bot nor its operator had any sense it was going to do this, and yet the police came and knocked on the door and said, "You threatened this in Amsterdam, this is illegal." But there was no mens rea. Another case where a software agent purchased ecstasy online, and again, the people behind it said that it wasn't their intent to do that. It also breaks down foreseeability in tort. So if you have truly emergent behavior, especially multiple systems interacting like we had with the high-speed trading algorithm issue, it's not necessarily true that any given actor in that system anticipated or could be said to anticipate that this level of chaos would ensue. And once it happens once, then you can go back and say this is the kind of thing that might happen. So for me, it's like and then finally with the idea of acting, the idea of it being embodied. There what I would say is that, law treats the physical differently. And so it might be nice for you to have an iPhone like we have here, and have all the software on that iPhone, and have it not all come from the people that provided the iPhone. This is actually, you're smiling because this is an Android, but I'm just using the iPhone. But it might be nice for the fact that Google or T-Mobile doesn't have to write all the software for my phone, right? But if a problem happens, if something goes wrong and it glitches and causes my phone to freeze up, if a computer glitches and I lose something really important to me, like I'm a reporter and I lose my big story, the law has actually domesticated that fairly well by holding that you can't sue Microsoft or Dell or whatever it happened to be for the loss of information that results from a glitchy computer. But the law doesn't do the same thing when it comes to physical, when it's bones and not bits on the line. So we may well have a law, which we do, Section 230 of the Communications Decency Act, that says that a platform like Facebook will not be held responsible for what users do on that platform. And that a platform like your iPhone won't necessarily be held responsible for the apps you download there. But if those apps wind up causing physical harm, then we're going to have to strike a different balance. So my point is just this, that each of these sort of fundamental components of a robot, each of them seems to present to me interesting legal puzzles, and that there may, I ultimately don't know what the payout is, but that there may be a lot of synergy and a lot of good at looking at them across the area. Please.
Yeah, you just said something very important. You teach torts anyway. You use the word harm. There's non-economic harm, there's economic harm, there's physical harm, there's all kinds of harm.
Sure.
It could even be virtual harm or self-induced harm. Harms of all sorts, but it's all harm.
I think that the very hard thing here, and the puzzle that we're going to see first and foremost, is the fact that there will be systems that are causing harm in the world, right? But yet, the elements of the relevant law will not be met. So there will be victims, but not perpetrators. There will be people who will be defamed. There will be stock markets that are destroyed. There will be,
now you're getting into the realm of paradox.
Well, what I'm trying to say is that what is interesting here is the fact that these systems behave in ways that if a person did it, it would be a tort or it would be a crime. And yet, because of the nature of the system, an element is missing, proximate causation or mens rea, right? And actually, some of the cases which I didn't get into go to this. So some of the cases I found in robot law history go to this question. It turns out that courts in the past have been looking for a human in the loop and will sometimes do kind of calisthenics in order to attribute something wrong to a person. So for example, in one case that David Vladeck actually found at Georgetown, David surfaced this case in which it looked like a plane crashed because of a problem with its autopilot, and the court couldn't figure it out. And ultimately, they held the airline responsible, not the manufacturer, because they were able to show that there was a load imbalance in the cargo hold. So they just looked for this, right? And so much so that actually a scholar has written a really interesting paper for my and Michael Flunkin's conference on robot law that says that people will be kept in a systems loop to act as a kind of moral crumple zone, meaning that they won't really be necessary, but they'll just be there so we can blame somebody when something goes wrong, right? And so I've seen case after case that suggests that courts will look for that person. So maybe we'll keep looking for people, but maybe it won't be fair. I wanted to let you voice it too, yeah.
So, I guess one question I have, you were talking about how the judges often didn't seem to understand robots. I guess one question is, perhaps with an eye to the state of science education or science acceptance of this country, whether the judges understand people, how people work.
Yes, yeah. Fair enough, right? No, I'm not sure that they do, right? So all you need to do is look at the use of eyewitness testimony in the criminal context and how we think of it as sacrosanct, and how all the relevant social science suggests that it's deeply flawed, for instance. I mean, yeah, I don't know that we understand people, but what I'm saying is that there's even a greater disconnect here. And I think that it's possible that, again, as we diversify sources of robot law, that there will be places that courts can go and look, so they won't necessarily be coming up with these models all on their own. For example, this is a very concrete example. Today, in the tariff schedule, there is a category for robot. You know what I mean? Because eventually they saw enough of these cases that the customs officials were like, okay, well, we need a rule. So now courts don't have to decide this anymore, because there's a separate category for how much you charge for a robot. So yes, but to your point about do they understand people, no, not necessarily. But I think they have a better mental model of people than they necessarily have.
That's really hard. I mean, that is so hard.
What is hard?
That courts, judges don't understand people.
Oh,
are you really prepared to argue that?
Well, I don't think that I'm saying at the level of neuroscience. So you're going to compare how a robot operates and thinks to how a person operates and thinks. I think for that to be a meaningful comparison, you probably should be doing it on the same baseline of a scientific comparison.
But,
my guess is they probably, to the extent they don't understand robots, there's also a legitimate concern that they don't understand people in the same sort of comparable way.
At the level of circuitry?
But I think we're supposed to be engaging with the speaker.
I'm sorry.
No, but I'll just jump into the fray, which I don't mean to commit myself to the idea that judges don't understand people ultimately, right? I mean, there are people, they understand people. One thing I would observe is that with respect to technology, there are periods of time when we don't have good expectations about how the technology will behave, and we wind up fashioning one rule. But then as we come to be more familiar with that technology, we fashion another. And one example of that would be hot air balloons. Originally, hot air balloons people didn't know how they worked. Bags of sand were falling down, they were landing all over the place, people getting burned. I mean, it was bad news, right? And so we decided initially to have strict liability for hot air balloons. But as we became more familiar with hot air balloons and how they behave and what the right ways to use them were, we then moved over to negligence. And so in that way, I imagine that it would be conceivable for our mental models to evolve to the point that we feel more comfortable with these robots as a community. And I can imagine a comparable process taking place with I have to say that I have some pretty sophisticated conversations now with judges about the internet. I'm going to help the Ninth Circuit with their retreat in a few weeks, talking about privacy and the internet. And when I had my preliminary conversation with some of the judges, they're pretty sophisticated on it. Now it's taken 20, 30 years, but I think that their mental model is pretty good of the internet. And I'm hoping a similar process will take place. With robotics. Yeah.
So we've had different accounts of robots. So one is sort of the circuitry of the robot. Another is basic functions that robots can perform. A third might be what uses the robot might be put to. A fourth might be the way in which regular people in society perceive robots. We could give accounts of robots within any of these frames.
Agreed.
It may be that the appropriate account for legal purposes depends upon the particular context. So you mentioned functionality. Usually one talks about functions, it's in a policy context, but when interpreting provisions of law, whether it's statutory or common law, we often make reference to the point of the provision. So the old case having to do with a lower tariff for dolls. So in order to figure out whether a robot is a doll for that purpose, it might be that we would have to get behind the point of that special provision for dolls. What was it about dolls that led the government to want to give them lower tariffs? It might have been a certain kind of appeal to some members of the society. And then the question would be, when you were trying to decide whether a robot is a doll for this purpose, is whether robots have the same appeal to the same segment of the society. I'm not saying that that would be the correct way to address the issue in every context, but in that context, that might be the right way of proceeding. This is a blindingly obvious point, but
an important one. I mean, so I think that of course there is a little bit of a tension there. So on the one hand, the court, in the case of the tariffs, it went to see the language of the tariff, and it said that dolls represent something animate. It didn't necessarily go beneath the surface and ask about what kind of interesting sort of historical trade wars led to us having a lower tariff for dolls, and you know what I mean, and whether they apply. They could do that. Maybe that's the right answer.
Another account of the point of the provision that it was. Right.
Sure. I mean,
my instinct is always that sort of dictionary, the meaning of the word interpretations are always misguided in law.
Yeah.
That's just not the way to proceed.
Yeah. Well, I mean, and that's fair, and I think that I think what I would say about robotics law and policy is it's not some binary where there's a robot and therefore there's certain rules that attach to it. It's that robots, like the internet, tend to have certain characteristics, and that those characteristics in particular contexts drive puzzles. So the notion of emergent behavior in tort forces us to ask questions about the limits of foreseeability. You know what I mean? To use a very fanciful example, a person purports to marry their robot, as people have done in Japan, for instance. Purports to marry their robot and then claims spousal immunity in a jurisdiction that continues to grant it, which almost very few do. Then we go back and we ask ourselves, well, what is the point of spousal immunity, right?
What is the point of marriage?
What is the point of marriage? So we ask these questions, right? And so what I'm trying to tell you, though, however, is that there is something interesting here, which is that unlike the fact that we would even ask a question like this is precipitated by a conflation between the machine and the person. Another example of this that might be helpful is one of the things that basically social science tells us is that there is a link between people who abuse animals and people who abuse children. And that link is so strong that many jurisdictions will have a policy on the books that says if you respond to an allegation of animal abuse and there's a kid in that house, you call social services and vice versa, right? If it turns out that we are hardwired to respond to anthropomorphic technology like robots, as though it were a social entity, and we had a person who went into a mall, and there's malls now all over the place in the United States and Japan and elsewhere, where they have these robots that are there as a kind of novelty. And somebody, goes and beheads that robot or destroys that robot or whatever it happens to be. Maybe you watch that person more carefully than you do the person that simply has, tagged a billboard. And in other words, it may be functional in the sense of, it's not that we have to be deeply committed to the notion that these things are social, only that that they feel to us as though they were social. And this is something that in my previous work I refer to as social valence, and that Jack thinks is better understood as substitution effect. But the point is, it's a unique facet of this anthropomorphic technology. So it's not at all to disagree with you. I think you're right. We do go back a layer and ask what's the purpose of this, whether common law rule or law. But I also think these technologies are generating questions that we wouldn't ask about everything. That's my sense.
Can I ask, I'm not a law professor or lawyer, I want to ask a non-law question. To go back to your example of the autonomous submarine,
Yeah.
maybe you talked about this, but how do you define autonomy, and where is the line at which something slips into autonomous mode? So I can imagine with the submarine is controlled, and then a switch is flipped, and now it's autonomous. That's easy to understand. But you talked about the robot that went into the gallery or went into a public space and did something unexpected. When did that robot slip from being under the control of its human overlords into being autonomous?
So
And how does that get defined?
Yeah. So if you're interested in this question, I recommend a book by David Mindell. I believe it's called Our Robots Ourselves. He's an automation expert at MIT, comes out of the science technology studies area. And he doesn't believe that there is any real natural distinction between autonomous and non. And I agree with him at one level. David's very smart. So the idea is that you could have a whole taxonomy of what autonomous means, and it could wind up being highly relevant to law. For example, you could tell the robot that it needs to perform a particular task, and therefore it does not get to generate the task in advance. And yet you could be unsure exactly how it's going to do that, and it needs to plan. So for instance, I want you to pick up this box like that Boston Dynamics stuff, does. Pick up this box and I want you to move it over there. But then it has to plan its route. It has to, it has to do trial and error. So you can give the machine an end state that you wish it to achieve and not exactly know how it's going to get there. And that's where a lot of emergent behavior winds up coming up. So for example, when the folks now at Google, at DeepMind, they're teaching this algorithm to play different Atari games. And they do that with reinforcement learning, which basically what that means, for those of you who are not familiar, is the idea that you give it a goal. You say, here's the things that you can do in this area. These are the things how you can use the Atari game. You have a joystick and everything else. And your goal is to get more points, right? And that's it. And then the game just plays and plays, and it tries out different things first at random. And then it sees that certain things it's doing are causing it to get more points. And then it goes through this process where it becomes like a great human Atari player, right? Where it's doing what you expect a great Atari player to do. And then, recursively, it gets to a state where it starts to play Atari like no human has ever played Atari before. And it finds loopholes in the game where it just gets infinite points because it found a particular point that, does, you know what I mean? And it just does things that nobody would do on their own. Another example of that is Amazon's Kiva Systems, which is a robotic warehouse company that they purchased it for $770 million a few years ago. And what it does is its tagline before it was absorbed by Amazon was Kiva Systems where objects organize themselves. What did that mean? Not only do robots run around these Amazon warehouses now and grab things off the shelf, but humans don't know where the things are. The algorithm is constantly analyzing what patterns of buying are happening at every given time, and they're putting things next to each other that you couldn't imagine. Why is it that Harry Potter books are next to toothpaste? Who knows, right? But the algorithm does that because that turns out to be incrementally a little more efficient. So it's not that anyone's, it's not like Kiva Systems is like, what should I do this morning? I'm going to organize a warehouse, right? They have to organize the warehouse. The question is how they do it. And that's interesting enough. It's interesting enough if it winds up triggering the kinds of concerns of the law. Yeah.
Now, follow-up. There's no way that a robot could be fully autonomous because it has been programmed by a human being. That's what we just said.
Yes. Well, in a sense, all robots can do is run their code, right? But that has long been observed not to foreclose the possibility that they would do things that were surprising. I mean, there's an old quote it's from the 70s, from, God, who is it? It'll come to me. About the problem with robots is that they do what you tell them to do and not what you mean. You know what I mean? Yes, ultimately they do. But it's like the human mind. I mean, don't think I don't take on board your point. I mean, the human mind is inscrutable, and we don't quite know. It could be functionally quite equivalent. That may be happening at a very high processing level speed and so forth.
We're running a genetic code.
A genetic code. Yeah, exactly. Yeah, exactly. I have long conversations. I have a neighbor who's a neuroscientist at the Allen Institute, and the Allen Institute has both a neuroscience and it has artificial intelligence, and we wind up having these fascinating conversations about what we know about how the brain works. And a lot of it seems like really complex, neural networks in the end. But I do think that at least juries and judges from, thousands of years of experience have a pretty good sense of how people are going to behave in particular circumstances, right? There's also really interesting work, this is a little far afield, but artificial intelligence and robotics hasn't, of course, just touched the law. It also blows up assumptions of economics and other things like that. And so I'm often in dialogue with economists about what automation does to them. A simple example being, say you automate the truck driver, because Chrysler has built this autonomous truck, right? And it's not autonomous; it has to do with its program, but it does drive itself from Philadelphia to California, right? Truck driving is like the #1 job in many, many states, and many states rely on payroll taxes. And if you were to transfer that much money from payroll taxes to capital, you destabilize the state's tax base. Or economists talk at a highly theoretical level. I read a paper recently about do we really get back to traditional economics because behavioral economics only applies to people? And in the future, we're going to be making decisions aided by machine learning, and therefore we won't have cognitive biases that we usually share, and so we'll be back to traditional economics. You know what I mean? And so it's like, it basically the process as I understand it, and this is true in the law and elsewhere, is we ask, first of all, what the technology makes possible that wasn't possible before, right? How does it change human experience? And then we ask, within a particular domain like law, what assumptions does the law have that no longer fully obtain, right? And we can do that with anything else, economics or whatever it happens to be. And that's the process that I and my lab and I've been following around robotics. Yes?
My question is a bit vague, but I guess at my level of education, it kind of has to be. People such as yourself that are involved in informing and engineering policy in robotics, to what extent are you concerned with your decisions and your precedents affecting the progression of the technology itself? In the sense that, the pioneers, they might be dissuaded because of some unsure sense of liability going forward.
Yeah, I think that's a very sophisticated question, in my opinion, at whatever level of education. So I mean, I'm deeply concerned with that, right? And the reason that I engage so much with, especially at the federal level, is because I worry that if we make wrong choices, both in terms of not having the right legal infrastructure and also, curtailing innovation, that robotics is going to be the first transformative technology since steam in which the United States didn't have a leading role. Because let me tell you that the folks in Europe and the folks in Japan and in Korea, they are taking this super seriously, and they are setting up these commissions and these other infrastructures and investing a lot. So one worry I have, for instance, is, remember I said the point about how this act is going to be a problem because you have this really promiscuous data environment, basically that's the internet, where information can change hands and go all over the place, but when there's a harm, courts find a way to domesticate it. Well, the best way forward for robotics is also for you to create a platform. In other words, you build a robot that doesn't necessarily do one thing, but it does anything people imagine, right? But if people are running all kinds of different apps on a robot or doing whatever people imagine with a robot, here in Austin, for example, some people hacked into a Roomba, the vacuum cleaner, and put a little frog outfit on it and played Frogger for real, like in real life, you know what I mean? Where they made a robot trying to cross the street. So if you can do that, right, then, and people are really potentially getting physically hurt, that we don't quite know how to domesticate that, right? So maybe that they can argue product misuse on the part of the manufacturer, but what's going to happen is you're going to build an open robotic system. It's going to be highly generative, highly innovative. But then, because you have the deep pockets, and from the perspective of the plaintiff, this machine just hurt you, you know what I mean? Then the manufacturer will ultimately be sued, I worry. And so in a paper entitled Open Robotics, I argue that we have to figure out a way in order to place some kind of limit on the manufacturer's liability for what people do with robots. Because if we, just as we have with the internet, and if we don't, then that will take away the incentive to create these open platforms. Does that make sense? So that's just one puzzle that I think we have to figure out. And we got really lucky with the internet. I mean, think about with the internet, the rule that a platform is not responsible for what users do on that platform. I mean, that was part of the law that was spectacularly struck down by the Supreme Court in ACLU v. Reno, except for the one provision, the Good Samaritan Act, Section 230, which is empowered, and it's a reason that even today, most every internet company, household name internet company is a United States company. Like that was just fortuitous, right? If we're not so lucky with robots, we're going to wind up getting having our lunch handed to us. Yeah. So you had another question, yeah?
First, I want to encourage more students to weigh in. There's a lot of students here, and you guys, that's a great question. I know there are more great questions out here, so please jump in while we've got Ryan here. And while you're thinking of your question, I actually would love to hear about your future research agenda, sort of where are you going from here? You sort of painted a picture for us of a field that's in its infancy. It's like environmental law in the 70s or certain aspects of national security law in 2001. There's so many different domains that one could go into. What field are you planning to plow?
Yeah, so I have two distinct research agendas, but they're related, right? So one of them is that I'm trying to develop, you hear it come out a little bit, I'm trying to come up with a method in order to assess what the impact of an emerging technology will be on law, okay? So I'm trying to come up with a formal set of tools that would allow us to not just speculate wildly, but to come up with a cyber law method. Because one of my observations about our field is that unlike other fields, whether it's sociology or computer science happen to be, we don't necessarily have a formal set of methods, you know, and often we approach questions one at a time and have a framework for the particular question before us. So my next project is really thinking through what would it mean to have a cyber law method. Do we have methods? We just don't call them that. Are there methods that we can import from other places, and so forth. So I have a project that is around formalizing an approach to the interrelation between technology and the law, right? In the robotics space, I want to continue. I want to take this project right now, where I've looked, sort of backwards, and begin to drill down on some of these very particular facets, right? So, for example, one question that I'm really deeply interested in is what are the parameters of control? So this goes to your question about autonomy and the nature of autonomy. So in lots of different contexts in the law, whether it's maritime or different areas of tort or whatever it happens to be, there is this question of whether or not there is effective control or exclusive possession. And these are issues that are very difficult to get your mind around. And I want to really drill down and figure out what is it that we mean when we say that something has been exclusively possessed or effectively possessed. And how does the prospect of robotics filling that role, what does it tell us about the sufficiency of the standards that we have, right? So whether it's the laws of war, where people are talking about whether there's meaningful human control for autonomous weapons, or it's exclusive possession for res ipsa loquitur, or it's the amount of control you have to exercise over, and I mean, there are so many different places where someone's control or possession is a border question, and it implicates robotics again and again. And so I want to, for instance, do a deep dive on that question, because I feel that I've laid out, maybe I'm wrong, but I feel that I've laid out my vision for what's interesting here at a very broad level. And now I feel it's time for me to try to drill down on each of these components. So those are the two things I'm thinking about. Thank you for asking. Student questions? In Colorado, they have a rule that the first question has to be from a student. It's Phil Weiser's rule. I knew that, yeah. Thinking about implementing that. Please.
I think it was in your paper, Open Robotics, but correct me if I'm wrong, that you spoke about instituting some type of insurance scheme to help with questions of liability when people are into better robots. And I was wondering if you could go into that a bit more.
Yeah, so thank you for reading even my previous work. I appreciate that a lot. Insurance is going to be powerful, right? Because insurance is a way we manage risk, obviously. And so although there may be growing pains, for instance, with driverless cars, it probably doesn't make a lot of sense for me to purchase a totally driverless car and for me to take out insurance, right? Because I may know basic things like how much I'm going to buy, but at the end of the day, I'm not in control of this thing. And yet, it kind of violates our norms to have the manufacturer have the insurance, if there is insurance, right? It's a strange thing. But what I argue in open robotics is essentially that the end user, the consumer, whether they're a business or they're an individual, will have a better sense of how they're going to use an open robotic platform than the manufacturer of it. In other words, if you buy a robot, you know how you're going to use it, right? You know how you're going to modify it. You know who it's going to be in contact with, in a way that the manufacturer, if it's a truly open robot, doesn't. And so what I argue in that paper is that with respect to insurance, it may be that the end user is better positioned to take out insurance to manage against the risk than is the manufacturer. I've been criticized for this paper, and I think in a way that makes sense, which is that it is too industry friendly. That is to say, at the end of the day, industries creating these things, they should bear some responsibility, and a lot of the work that I did is basically offloading that responsibility onto society or the individual, all in the name of being innovative, you know what I mean? And I've since sort of revisited that position, and I've since come to the view that an important role of government will be to set certain standards of adequacy in terms of how certain we are that the robot will behave the way that it should. And that's come out in my conversations with the Federal Aviation Administration. Because if you think about what the Federal Aviation Administration does for flight critical systems, they certify them against error 10 to the minus 9. Do you know what I mean? I mean, for mission, it is an absurdly rigorous process. And I don't think we need that for everything, for drones or whatever it to be. But there is a role, I think, for talking about how likely is it this thing's going to create enormous risk. And so I've revised that position a little bit. Yes?
Yeah, it is a very good question, but I think it's more about the nature of insurance than it is about the nature of robots. And insurance has to map the locus of liability, or of the underlying liability. If the user is liable, then the user should be required to get insurance. If the manufacturer is liable somehow, then the manufacturer should be required to get insurance.
But if we're designing a system, we can allocate where that responsibility should be, which then in turn drives the question of who is going to take out insurance.
Right.
And as you know, of course, that sometimes we decide to allocate it in a particular place because of calibration-like reasons. You know what I mean? Yeah.
So it's circular.
It's circular, but we can think through where to put the responsibility if we feel confident that we can map what ramifications. So we can locate like for driverless cars, we can decide in advance that we're just going to affix strict liability to the manufacturer driverless cars. That will of course motivate them to take out insurance. And if we feel comfortable modeling whether that would be net positive, right, we can do that. Whereas conversely with home robots, I argue that it would be a net positive to have the end user do it. So we allocate, that would be a way of driving this. Yeah.
So we've reached the end of our time, but before I let you go, I wanted to invite anyone who's not already on the event list for the Strauss Center who's interested in robotics, artificial intelligence, cybersecurity, legal policy, and STEM interconnections. Let us know. I think we have a sign-up sheet sitting over there. Put your preferred contact information, default email, but you can put something if you wish. And otherwise, let's thank Ryan Calo for a